Well, good evening, everyone. We've got a fair number now who've joined us, and I can't see anyone else waiting in the virtual waiting room. You're all very welcome to the first of our two autumn webinars. Thank you very much for joining us. You will see on the slide that we have set out the ground rules, which I'm sure you are all now familiar with, living in the regime which we've currently been enduring since March of this year. If you can please, when you're not speaking, mute your microphones, switch off your cameras unless you're speaking. Avoid any temptation you may have to take control of the PowerPoint slides. You'll upset Caighli and Alistair if you do. And if you have any questions, then please can you use the chat function and the speakers will answer them at the end of their talks to you. When I closed our first webinar of the year in April, I said that I'd hope to meet you all again in more convivial surroundings at Avery's in November. Well, for reasons you'll well know, that's proved singularly impossible. So it is that we have this webinar this evening, and we have the second of the series on the 10th of December, when we'll hear from Mary Cowie on sentencing defendants with mental disorders. And Ray Tully will share with us his experience of being junior counsel in the Carl Beach trial. Tonight we have, first of all, Caighli, who will help us with online grooming offences and so-called paedophile hunters.
Unmute your speakers.
And then Alistair on. We are recording this evening's webinar, so you will be able to access it, I'm told, on our YouTube channel. I can't help you with what's else is on the YouTube channel, but why not have a link? You'll have a look. You'll find the link on our website. Before I hand over to Caighli, can I remind those of you who have not yet purchased your copy of our fabulous book, Practical Advocacy in the Crown Court. It is available from all good publishers and bookshops. And if you see anywhere on the Bloomsbury website that it's not available, that's not accurate, I'm told. You can get it for a startlingly good low price. And if you want it signed, then we'll do it. If you prefer we don't sign it, then of course we shan't. But it's available. Please buy it. Mr. Justice May said this about the book. The book will be welcomed by all new practitioners in the Crown Court and many experienced ones too. It is a highly useful, practical guide to all types of pre-trial mentions and case management hearings, trials, sentencing, and also appeals. What else could you want for Christmas but a copy of our book if you haven't got one? Enjoy the speeches, enjoy this evening, ask any questions you want, and if you have any ideas about topics for future webinars, just drop one of us or the clerks an email and we'll see what we can do to assist. Right, that's enough from me. Over to Caighli, who'll start the evening. Caighli.
Thanks, Chris, and good evening, everyone. I'm going to be delivering a talk on online grooming offences and paedophile hunters, as they like to be known. The reason why I've chosen this topic is because there have been a huge number of recent authorities, especially in the last year, and also because these sorts of offences are as prevalent as ever. And numbers are likely to keep increasing. The overwhelming majority of these sorts of offences take place online, involving sting operations, undercover police or vigilante groups, and they throw up lots of different issues. I'll be focusing on two main ones, which will be familiar to many of you. The first is, when sentencing, how should harm be assessed, particularly in cases where there was no sexual activity, and that can be divided into two categories: cases involving real victims but where activity hasn't taken place because it just didn't get that far, and then second category of where victims are in fact decoys or fictional, so sexual harm wasn't even possible. And then the second thing I'll be looking at towards the end of the presentation is just a general overview of the ways of challenging prosecutions stemming from undercover operations, and in particular vigilante groups, when, for example, might an abusive process have legs, and then there's a few other recent cases on online paedophiles and human rights, which I will quickly look at. So we're all familiar with these offences, and the offences that we're usually talking about when we're talking about grooming and inciting are the ones at section 14, 15 and 15A onwards. It's in the context of those offences that recent cases have been decided, but a number of other of these offences can be committed online, for example, sexual communication. And of course, when you're dealing with a section 14 offence of arranging or facilitating a sex offence, for the purpose of sentence, you have to refer to the guideline for the offence which was facilitated or arranged. And very often that's section 9 or section 10. I'm just going to say something quickly about charging, which seems to cause a little bit of confusion in this area. There are, of course, grooming offences which are only complete when there is activity which is directed towards or affects a real victim. So, for example, section 15A, you cannot engage with sexual communication with a child if the child is in fact a decoy. So that would properly be an attempt when it's a fictional child. The problem arises usually in the context of section 14 and, for that matter, section 15. So section 14, which is the arranging or facilitating of a child sex offence, and section 15, meeting following grooming. And we see time and time again that these offences are often charged as attempts on the basis that there was no real victim, the child involved was a decoy. And the authorities, including the recent case of Privett, which I'll come on to in more detail, have made it clear that the offences are preparatory and therefore they are completed when arrangements have been made with the relevant intention, or when a defendant has travelled with the intention of meeting a child intending to commit a relevant offence. And so in those cases, they're not to be charged as attempts simply by virtue of the absence of a real victim or real child. Situations slightly different with section 10, incitement. The offence is completed when incitement has taken place, even if no activity has. But the completed offence does envisage a real child, and so it would be an attempt if the incitement was directed towards a fictional child. But it is important to bear in mind that even preparatory and inchoate offences can still be attempts. And so, for example, the case of Robson, the defendant here asked a sex worker if she knew any 12 or 13-year-old girls for him to have sex with, and that's as far as it went. She didn't tell him. It didn't go any further, and that was quite properly charged as an attempt at arranging a child sex offence. The case of Lydiard from last year, again, was another one where it was properly charged as an attempted section 14, attempted arrangements. The defendant there had tried to get a fictional child to agree to arrangements to meet, but the arrangements were never made or even close to being made. He obviously had an intention to commit a relevant sexual offence, but the court in that case treated the fact that the child was fictional and the fact that it was an attempt as separate and distinct factors. There are problems ultimately with that decision that we'll come on to, but that as a principle seems to be right. So turning then to assessing harm when sentencing, and I'm going to talk about this largely in the context of these offences, which is what recent authorities have been dealing with. And as I'm sure everyone knows, when you have a client charged with section 14, arranging or facilitating a child sex offence, the guidelines suggest that you must refer to the substantive offence which the offender was intending to arrange or facilitate, and very often that's section 9 or section 10, sexual activity with a child, or inciting or causing a sexual act. So we look at the guidelines for sections 9 and 10, and hopefully they are the same guideline, and just look at harm, penetrative activity in category 1, and then other sexual activity in category 3. And as you'll all probably know, it makes a huge difference. Category 1A carries a starting point of 5 years, and Category 3A carries a starting point of 26 weeks custody. And so the fact that there have been two competing lines of authority about harm should be assessed, and that they tend to fall either on the side of Category 1, where Category 1 harm is intended, or Category 3, makes a real big practical difference. The problem is that there have been two very diametrically opposed lines of authority. And the guideline says this about arranging or facilitating: in such cases, the level of harm should be determined by reference to the type of activity arranged or facilitated. And one would be forgiven for thinking that means that you refer, therefore, to what was intended. If the defendant intended penetrative activity, then it's going to fall within Category 1. The case of Privett then was 4 appeals heard together. Mr. Privett and Mr. West were 2 of the 4 appellants. They were charged with facilitating or arranging a child sex offence, and they were both intending sexual activity with a child under Section 9. Both appellants received pretty significant custodial sentences on the basis that the cases fell within Category 1A. The defence contention was that the cases fell within the lowest category of harm because the child was fictional. And I won't go through each case, but this, in essence, Baker, Buchanan, Stilwell, and so on, that was the line of authority which appeared on the face of it to support the defence contention. So a line of authority from at least 2014 right until the present. Lydiard was the most recent in that line of authority, where the court was so confident that there was, if there was no child, it was Category 3 harm, that it made pretty scathing remarks about counsel in the lower court and substituted 1 year for the 3-year sentence that was imposed in the court below. The problem was in Lydiard that the court simply wasn't referred to the other competing line of authority. But in Privett, the Court of Appeal were, and the prosecution argued pre-categorising cases without considering the individual facts was wrong. And they also referred to Section 143 of the Criminal Justice Act, which tells us that it's important to consider intended harm as well as actual harm. But of course, that doesn't tell you what that means in the context of the guidelines. So these are the cases which went the other way, as opposed to cases like Baker and Buchanan, and were in favour of categorising by reference to the harm which the offender intended. Bayliss was pre the 2014 sexual offences guideline, but was much more limited in the reduction that should be made to reflect the absence of actual harm. And as I say, unlike in Lydiard, the Court of Appeal in Privett explicitly recognised there were two competing lines of authority and decided that this was the correct approach, that you start by identifying the category of harm the defendant intended by reference to the type of activity arranged or facilitated. And then the next step is to adjust the sentence in order to ensure it's commensurate with or proportionate to the applicable starting point and range if no sexual activity occurred. Now, it's not particularly clear, that guidance. Does it make it any clearer in the next paragraph? Well, they're explicit that they were endorsing the approach of Bayliss, essentially that the absence of actual harm requires some reduction from the starting point. What does it mean? Well, probably that if category 1 harm is intended, then category 1 is the starting point, and it might be helpful to think of the reduction that the court then has to go on to make as akin to the sort of reduction the courts make when sentences are passed for attempts. But the reality is that line of authority that suggests that absence of harm automatically places it within category 3 has been discredited, and it's likely to mean that sentences for these sorts of offences will increase. And the court also acknowledged in Privett that this meant that some cases involving fictional victims would be treated more seriously than some cases involving real victims. And of course, that you think about it, that has to be right. Unfortunately, the saga didn't end there, because we then had the cases of Manning and Russell. And Manning, which is the COVID case, the one that we all cite in court when trying to avoid a lengthy custodial sentence, was also a sex case, and it was decided the day after Privett, unfortunately by a differently constituted court of appeal. And it was a case involving a defendant who pleaded guilty to Section 9 and Section 10. He had met with a real 15-year-old on a number of occasions, kissed her, touched her breast over clothing, and he also pleaded on the basis that he had intentionally incited penetrative sexual activity, not in the immediate future, but at some point before his 16th birthday. But sex did in fact occur, and everyone agreed, although it was culpability A, the sentencing judge regarded it as category 3 harm, other sexual activity, because no sexual activity actually took place. And the Court of Appeal in Manning agreed that it was unduly lenient and gave him 2 years instead of the 12 months suspended that he received. But everyone in the Court of Appeal considered it was a category 3 case, cited Baker, absolutely no discussion or reference to Privett, which had been decided the day before. Russell, exactly the same. This time it was a fictional victim, but it was a attempted Section 9 and Section 10, no discussion of Privett, and focused on authorities like Baker, which had gone the other way and which are pretty explicitly discredited in the case of Privett. And this isn't the Court of Appeal making a deliberate distinction between Section 14 cases and Section 9 and 10 cases. If you read the judgments, they're just simply not made aware of Privett or indeed the other authorities that go against Baker, and there doesn't appear to be any logical reason as to why there should be the more lenient approach in Section 9 and Section 10 cases where no sexual activity has occurred, and then a harsh approach for Section 14 cases. Thankfully, Woolner in September of this year, which came after Privett, but Privett wasn't reported until Mr. Woolner had been sentenced. And essentially, in this case, it was an attempted Section 14, which had been incorrectly charged, but that didn't really have any bearing on the decision. And the Court of Appeal was pretty clear that Bayliss and Privett are correct. Manning and Russell proceeded on the incorrect basis, and there was a very comprehensive review of the authorities in Woolner, and it makes it reference to the fact that courts in Manning and Russell, that they didn't have their attention drawn to authorities that they should have had regard to. And so for that reason, I think that is the end of the saga, that Privett and Woolner prevail on that point. Because, as I say, the Court of Appeal does a much more comprehensive and careful review of both lines of authority than happens in Russell and Manning. So that deals with that issue. I'm going to just talk briefly now about things which relate to the fairness or propriety of cases involving undercover or vigilante groups. And we start by recognising that vigilante groups on the internet are not governed by the Regulation of Investigatory Powers Act 2000. Cases which have, in which that's been argued, have not been successful. So what about abusive process on the basis of entrapment? Well, it won't surprise you to hear that it rarely succeeds. The leading authority on entrapment, incited by the state, is the 2001 case of Loosely, in which Lord Nichols gave this statement, which is often cited. A useful guide is to consider whether the police did no more than present the defendant with an unexceptional opportunity to commit a crime. And ultimately, the overall consideration is always whether the conduct of the police or the law enforcement agency was so seriously improper as to bring the administration of justice into disrepute. So that's the overall consideration, and that's the guiding principle as far as entrapment is concerned in all cases. But what about in the context of sting operations? Well, the 2018 case TL, the appellant here had chatted online to a vigilante paedophile hunter who was posing as a fit 14-year-old girl. He made arrangements to meet for sex, and he was then confronted in his home address by this vigilante group along with the police, and the trial judge determined that the case was an abusive process, that he had been entrapped. And the Court of Appeal made clear that the power to stay cases of entrapment as abusive process was to ensure the rule of law was upheld and to refuse to sanction the prosecution of state-created crime. So in other words, the principles behind entrapment and abusive process are applicable really to the police and state-created crime, and not as applicable to private individuals. In this case, Council for the Regulation of Healthcare Professionals and the General Medical Council and Saluja 2006 case, this was an undercover journalist who posed as a patient, and she asked for a sick note to have time off work for a holiday. She was very clear with the doctor that she wasn't ill, but the doctor agreed to provide a certificate anyway. And disciplinary proceedings that had been started against the doctor were stayed for entrapment as an abusive process, but the High Court disagreed and said that essentially misconduct by state agents are in a different category to those who are private individuals. However, there is some hope, because potentially where there is gross misconduct, it may be an abuse even in the case of private individuals, and this might be the basis on which one could challenge evidence obtained by a vigilante group. And para 81 of that judgment, Golding J says that the authorities leave open the possibility of a successful application of a stay on the basis of entrapment by non-state agents, given sufficiently gross misconduct by the non-state agent. It would be an abuse of the court's process and a breach of Article 6 for the state to seek to rely on the resulting evidence. And so we're talking about serious conduct which would compromise the court's integrity. And so you can imagine that the situations in which that arise will be rare. What about PACE? What about Section 78 of PACE? Well, there's the case of Shannon from 2001. If there's good reason to question the credibility of an agent provocateur or to doubt their evidence because of manipulation or selective editing of any recorded evidence, that evidence can be excluded. And you know, if you're going to go down that route, voir dire might be the way to do it and avoid a trial. However, it seems inevitable that the evidence will need to be given by that individual, by the paedophile hunter, so that you can benefit from cross-examination of them about the evidence and the integrity of their evidence. And you know, paedophile hunters, you have to assess their motives, their agenda. Are they in it for the publicity? Do they have a large following on social media? Are they seeking to get money from it? Was there a level of persistence? You don't have to look very hard to find examples of paedophile hunters using underhand methods which undermine faith faith in investigations and prosecutions themselves and faith in the system. And it was seen that every case has to be assessed on its facts, but that there is evidence that paedophile hunters, as you might expect, are less concerned about justice and more concerned about furthering their own interests. And this case of David Poole was a case where the issue was that the defendant believed the girl he was set up to meet with was over 18 and had been set up by these paedophile hunters. And during the course of the sting operation, he'd been provided with pictures of the girl. He said she looked over 18 in them. And at trial, the leader of the vigilante group gave evidence. He provided pictures to him and she was clearly a child. But during the course of the trial, he was deliberately vague, gave very inconsistent answers. So inconsistent that the prosecution dropped the case, and the trial judge remarked that the witness was trying very hard not to reveal what images he gave to the defendant. I'm just going to deal finally then with this recent case of Sutherland. Using evidence procured by vigilante hunters is not incompatible with the accused's right to private life, which is not surprising. The appellant's sexual communications with a child, albeit fictional, were not worthy of respect under Article 8 because they were criminal in nature. He couldn't have had a reasonable expectation of privacy in relation to them, and had Article 8 even been engaged, it was not incompatible with using the evidence to investigate and prosecute. Now, this case was dealing specifically with a paedophile's online activity, which was criminal in its content and purpose. It obviously can't mean that a paedophile has no rights to privacy. And there are certainly going to be cases when, notwithstanding what they may have done, turning up to their home address, live streaming it, confronting them in the presence of their family members, not for the purposes of investigation, but when it's done purely for effect, that would at the very least engage Article 8, in my view. But then you have the hurdle of whether using that evidence obtained in that way is disproportionate to the need to prosecute it. And unfortunately, very rare indeed that an argument along those lines would be successful. So that's the end. Any questions, please? Any point in pleading to a Section 10 offence rather than Section 14, or no point at all? Probably not. I think after the recent authority, probably not. Before Wootton and after Manning, you might have been able to argue that there was some distinction being drawn between assessing harm in the context of Section 10 and Section 14, but there's no logical reason as to why you would assess harm differently in those circumstances. It'll depend on the circumstances of the case, I think. Right, I don't think we have any more questions, so I'll hand over now to Alistair, who will be delivering the next presentation.
Good evening, and thank you for attending this evening. This time last year, how many of us had heard of Zoom? And how many of us had attended a court hearing on a laptop perched on our kitchen tables? But yet here we are now, fairly accustomed to remote working. And in this talk, I'm going to look at the story, if you like, of virtual hearings, some practical tips for making these hearings effective, and some issues which are likely to arise in the future if, as we anticipate, virtual hearings are going to be here for the long run. So with Christmas now only a month away, this talk with past, present and future has a bit of a festive ring to it. I'm going to look at the ghosts of virtual hearings, past, present and future. In terms of the past, we've seen historically a gradual incremental increase in remote hearings pre-COVID-19. We're going to look at the rationale and the circumstances in which the court has allowed remote links in the past. We're going to look at the situation now and some of the best practice tips for that, and also look at the future and where we go from here. So starting with the past, there's been a gradual introduction of remote attendance. A number of statutes starting really in the late 90s with the introduction of more video material into courtrooms and the internet. These statutes made provision for some parties to attend remotely. We had defendants in pre-trial confiscation and sentencing hearings, which was permitted under the Crime and Disorder Act 1998. And then in 1999, under the Youth Justice and Criminal Evidence Act, provisions that many of us will be familiar with. Vulnerable witnesses under Section 24 were permitted to give evidence via a video link as one of the special measures we often see in trials. And in fact, less commonly used, but one that is available, is provision for vulnerable defendants under Section 33A of that Act as well. And then slightly more recently, in 2003, the provisions were made even wider under Section 51 of the Criminal Justice Act, which ensured that any witness could give evidence via a live video link to ensure the efficient administration of justice. So this enabled people in different parts of the country to give evidence via video links. In addition to that, the criminal procedure rules have allowed for defendants and in fact advocates to attend pre-trial hearings via a video link. And the test for that is whether the defendant can effectively participate in the proceedings. So again, it's not a provision that's used very often, but we will on occasion have clients who come from different parts of the country and will ask that question, whether they can attend a hearing remotely. Well, actually, the power's been available for some time now for them to, in effect, be beamed in on a video link for any pre-trial hearing. And in 2017, the Ministry of Justice commissioned an impact assessment into making better use of video technology in courts. The objective of that impact assessment was bluntly to save money and to look at whether they could make court cases, court hearings more efficient. And the report actually has some quite radical proposals. It proposed wholly virtual hearings that in effect would be conducted without anybody being in the courtroom at all. Remote sentencing hearings and even remote trials were canvassed in that impact assessment. But despite some of these quite radical proposals, that report was shelved and not an awful lot was done with it. And so pre-COVID, the situation we had was one where there was a clear presumption in favour of attendance in person. Remote attendance had been introduced cautiously and incrementally. And although there had been some allowance made for convenience for witnesses and for advocates, it was generally introduced where there was a need due to witnesses' youth or vulnerability. We had what you might call a traditional model of courtroom advocacy, and where you couldn't do a hearing, somebody else would hold the case for you. I've talked there about local firms and local bar. Of course, defendants can instruct anyone they like, but the traditional model, essentially due to geography, has meant that in most cases, people instruct local solicitors and local barristers. Let's go back. But there was a growing desire for courts to fully embrace virtual hearings, both in the report commissioned by the MOJ, but also some academics, and Richard Susskind is perhaps one of the most prominent in this field. He wrote a book called Online Courts and the Future of Justice. Not as good as the Crime Team book, obviously, but it's one that was advocating at that stage online courts and making more use of technology in courtrooms. And that was published last year. But even he wouldn't have foreseen what was to happen this year. We come now to the present and to COVID-19, which has been really the game changer. Sometimes dramatic events mean that we have long-lasting changes, and that these sorts of events are required to be the catalyst for long-lasting change. And in this case, remote hearings became a necessity because of COVID-19. And you'll recall that initially the courts did sort of soldier on. There was a suggestion that any case of 3 days or less could continue, before eventually they decided that actually they had to close the courts for a time. Now, it may have been inevitable, this change, but there's no doubt that COVID-19 was the catalyst. And Crown Courts have since allowed all hearings, except trials, to be conducted, at least in part, remotely. And after initial teething problems with technology and the like, remote hearings have become really quite routine. So in terms of provisions, these can be found in the Coronavirus Act 2020. This made amendments to section 51 of the Criminal Justice Act. And schedules 23 to 26 are worth a read, because they set out in some detail the situations in which virtual hearings can take place and the specific parties who can attend remotely. Schedule 23 has quite a wide ambit for video hearings. In a nutshell, it allows for judges, advocates, defendants and witnesses to all, in certain situations, attend remotely. And the only exception are juries. As yet, there is no provision to allow juries to participate remotely. But you might recall there was at one stage talk of having remote jury trials, and I believe a couple of experiments were carried out to see how it would work if we had remote juries. But Schedule 24 has some limitations. It goes through specific types of criminal hearing and outlines provision for those. It will come as no surprise, for example, that defendants are not permitted to dial in from their living rooms for sentencing hearings, for example. But in other cases, other situations, they can attend hearings remotely. And the test for whether video link should be permitted, where it can be permitted, is whether it's in the interests of justice. And as you probably found from your own experiences, the courts have been quite willing to allow people to attend hearings remotely. Schedule 26 provides some quite niche but significant rules. These relate to appeals against requirements or restrictions imposed on those who are potentially infectious. Those hearings take place in the Magistrates' Court. And in that situation, the presumption is actually in favour of wholly video hearings. So that's everybody, all parties involved, attending remotely, unless the court directs otherwise. So the Coronavirus Act actually introduced quite wide-reaching, quite significant provisions in terms of remote hearings. And as you probably know from the news, it has a 2-year time limit. That can be shortened or in fact lengthened by 6 months at ministerial discretion. So we might have these powers in place for some time yet. I'm going to look a little bit at the rules for conducting virtual hearings. There isn't an awful lot, in fact, in terms of rules. But right at a very early stage in March, the Court of Appeal issued some initial guidance for remote hearings. At this time, CVP, that we tend to use now for these, hadn't been introduced. People were using Skype or Microsoft Teams. And there were 3 basic rules that they issued. These might seem quite obvious. And the first one is business attire should be worn. Now, most people, from my experience, have done that, but this did cause some issues in America. One Florida judge complained about the fact that advocates in his court were attending remotely in swimwear from their beds. He talked about one advocate being under the bed sheets and one advocate being shirtless, in fact, when attending a remote hearing. So he was quite perturbed by that. But generally, people have adhered to that rule and worn business attire. The backdrop needs to be neutral and appropriate for a court hearing. And again, it's perhaps obvious, bearing in mind what the likely camera shot would be, but advocates need not rise when the court assembles. In civil hearings, they've actually issued a protocol with more details about how virtual hearings should be conducted, but there's no equivalent as yet for criminal hearings. But you might find it helpful to read the guidance on the government website for defence practitioners. That was issued in June. It envisages all virtual hearings taking place via CVP. And it covers the hearing itself, but also matters such as speaking with clients in advance and consulting with the prosecution. So I thought it would be helpful to look at a few advantages and disadvantages of virtual hearings. And you might have some of your own as well to add to this list. Certainly in the short term, virtual hearings are safer. They may even be safer beyond that. You may already have found that they've allowed for more precise scheduling of hearings. And I certainly hope that actually the courts continue with that, because we've all been in situations where we've had a case listed at 10 a.m. but been waiting around for a very long time to get on. What virtual hearings have meant is that courts are much more willing to list hearings at certain times, and that has enabled us to plan our time better. It saves travel time and has a positive impact on the environment as a result. It allows for better time management more broadly. And you can attend different hearings in different courts on the same day. So in that respect, they're more flexible. And in terms of prison conferences, those of you who've been able to conduct conferences via CVP, as I did today, in fact, may well have found that it's much easier to do them online. You haven't got to go through the rigmarole of going through security checks and waiting for your client in the prison, going through the difficulty of booking and then finding that the appointment has been changed or moved or doesn't exist. It is easier in one sense to dial in remotely from your home. However, you may have found there are some limitations in terms of how effective those conferences can be. We're going to look a little bit towards the end of this talk about some of the limitations in terms of connecting with people when you are speaking with them over a video link. And here are some disadvantages you may have found. Technology can be unpredictable. Despite the best efforts of the court estates to get things working properly, there are still glitches. These things can happen, and they can be very frustrating when they arise. There are practical limitations in terms of having conferences with your client before and after the hearing and discussing the case with your opponent and using an interpreter. All of those things are, you may feel, much easier when you're in person. One of my concerns about remote hearings is point number 3, the difficulties in identifying specific client needs. It is, from my experience, easier to identify issues such as mental health or learning disability when you can speak to somebody face to face. When you're trying to conduct those conversations over a video link, there is that disconnect. It may be more difficult to spot some potentially very important and quite significant issues a client might have. Courts have taken an inconsistent approach to the types of hearings that can take place virtually and the way in which they're conducted. There are a few courts, for example, that haven't yet got CVP and they're using other platforms. Some courts are more strict about the nature of cases that you can dial into and requiring your attendance. There's as yet no overarching protocol for people appearing in the criminal courts. There is a risk of it undermining open justice. Traditionally, anybody can walk into a hearing and see a hearing conducted in a courtroom. At the moment, that isn't always possible. Some courts have put in place provisions for hearings to be televised, in effect, in another courtroom, but not all have that in place. And there's also a risk of proceedings being illegally recorded. It's far easier to identify someone recording a hearing if they're sat in a courtroom with their phone recording it. It's not really possible to see what's happening when people are behind their computer screens. So here are a few tips really for the conduct of these hearings, and I've called it emerging best practice. These are some of the things from my experience and from others that tend to work quite well for virtual hearings. Perhaps the most important one of all is to speak to others in advance. You probably all do this anyway, and it's perhaps common sense, but speaking to your instructing solicitor or the advocate you've instructed, your client, your opponent, all in advance of the hearing is particularly useful when you won't be able to see them in court and have those usual conversations in the robing room or outside of court before the hearing. It's important to have clear instructions and anticipate the issues that are likely to arise during the hearing, because once you're sat in front of your screen and the hearing begins, it's much more difficult to break off to take further instructions. Preparing a written note in advance can be really useful, especially in sentencing hearings. You take the initiative by doing that. You can set out your stall nice and clearly at the outset, but also by having a written note, it means that if there are any issues with technology, if the microphone doesn't work, for example, if it's more difficult to hear you, at least you've got your submission set out in writing nice and clearly in advance of the hearing for the judge to read. Keep submissions succinct and precise. Well, that tends to go for any hearing, but even more so when you're over a video link. There is apparently a phenomenon called Zoom fatigue. People's attention can wane sometimes, so it's really good to keep them short and to the point. And again, perhaps an obvious point, make good practical arrangements. Have a private room somewhere where you're not going to have too much background noise or interruptions from children, for example. Have a non-distracting background, so don't want any sort of garish posters or anything like that. A good internet connection. Have your papers to hand so you can refer to them quickly, and use a microphone or a headset if necessary. In terms of pitfalls, again, these may be quite obvious, but it can be helpful to just sort of look through them and reflect on them. Speaking slowly is even more important than usual. The sound quality, some of you may have found this, can be quite poor in court. There can be a lot of feedback. You can often hear an echo of yourself coming back once you've said something, and the signal can come and go. So it's really good to speak as slowly as you possibly can. As always, it's important to have a rapport with your client. It can be more challenging over a video link. It's really important to have that connection. Have a plan for situations in which you would usually obtain written instructions. This can be really difficult when you're in a completely different place to your client, especially if your client has particular needs or there are difficult issues that arise in consultation that you'd normally get a written endorsement for. Think about how you'd get around that. You might want to draft something and then read it over the link to your client before the hearing, so it's really clear. You might want to draft something in advance to try to get their instructions on, but just have a think about how best to deal with that should it arise in the hearing. And also test the link beforehand. It's always good, I think, to dial in about 5 minutes beforehand, make sure it's working okay, and you've connected to the court before the hearing starts. So what of the future? I've used a picture there of Ghost of Christmas Future. You'll recall in A Christmas Carol, the Ghost of Christmas Future talked about doom and rather negative consequences unless things changed. Hopefully the consequences for virtual hearings won't be quite so bad. But there's no doubt, as I said at the outset, that virtual hearings in one shape or form will be here to stay. Recent events have required a pragmatic approach. People who had some anxieties about virtual hearings have put those aside just to enable cases to proceed. But there is precedent in history, really, for emergency measures becoming permanent. And it seems that will be the case with virtual hearings. But the question really for us and for the courts in the future is what hearings should be virtual and which ones should take place in person? In effect, where does that line get drawn? And the question really is whether this could be a slippery slope. There's no doubt that in terms of convenience, virtual hearings have a lot of positives. And there's no doubt that many of us have found it quite a good way of working. Those long trips we have to take different courts, the waiting around, it can be very frustrating. So anything that helps with that burden and allows us to work more productively has to be a good thing. But there are clearly potential issues with virtual hearings. I'm going to look at a few of those just at the end of this talk. So the first one is expediency versus quality of justice. There's very little evidence about the impact of remote hearings, but there was a 2010 study some time ago now, but that found that defendants who appeared on a video link were more likely to get a higher prison sentence and less likely to receive a non-custodial sentence. It's difficult to tell exactly why that is, but one possibility that I've suggested here is the risk of losing sight of the individual at the heart of the case. It's felt that it's perhaps easier to connect with somebody on a human level when they're actually physically present in the room. And there's a risk that when someone's on a video link, it's easier to become detached from that particular individual. So one concern might be that in the push to make hearings more convenient, quicker, more expedient, more efficient, more cost effective, that actually we lose sight of the fact that there's someone's liberty at stake at the end of it. A person with a story to tell and a human being at the heart of the case. Then there's the issue about advocacy itself. Computer screen advocacy, if I call it there, is quite different to courtroom advocacy. There's a risk that's more difficult to communicate in an impactful way. Part of that is because of the issues that can arise with the video link, but also experience suggests that it is easier to talk to someone when you can physically see them in the room with you. That part of advocacy isn't just what you say, but the way in which you deliver it, the tone, the nuance, the emphasis. All of those things are more difficult to convey over a video link as opposed to actually being able to see a judge face to face. Is there potential to undermine the value of advocacy? We don't do this job for entertainment, but at the same time, there is perhaps something in being able to speak to an audience in a courtroom as opposed to speaking to people over a video link. And as I've already hinted at, does it compromise the ability we have to connect with one another? Is there a potential for less fairness, less empathy, less understanding between people? The alternative way of looking at it, though, is that with the introduction of more video technology, is there the potential for hearings to be broadcast? Now, already there's been talk of sentencing hearings and sentencing remarks being live streamed, and that might have some good that comes out of that. The tabloid press often complain about sentences imposed in certain cases without really understanding the decision or the mitigation that was advanced. Might televising that actually improve our understanding? Might it actually improve advocacy? But of course, there are also caveats to that as well in terms of criminal proceedings being recorded. So that's one possible risk, but equally it could be something that's positive for court hearings. The final one is looking at the business side of it. If parties can dial into hearings from anywhere in the country, I've put in brackets, or beyond, what impact will that have on the way that cases are handled? As I said at the beginning, although defendants can instruct anyone they want, traditionally they tend to go for people that are more local because of geography, because they're familiar to them, because they have that relationship with them. All of those are positives. And although that might continue, what happens when anybody can attend a hearing from anywhere in the country? How does that change the model we've had traditionally in terms of how criminal cases are conducted? Is there a prospect that it undermines that presumption of going to the local firms and local bar? And is there, as I put there, a risk of a race to the bottom? It's difficult to predict what the future holds, but certainly the model of having local circuits, local firms and local bar could well be undermined if virtual hearings grow and grow and grow. Suddenly there's a prospect of going to anybody in the country to represent you, and that person be able to dial in from anywhere in the country. And the danger could be that we start seeing very, very large monolithic firms taking a lot of work and doing all their cases from one particular call centre, in effect, and dialing into different courtrooms across the country. Might it undermine the chambers model as well? There'd be no need, for example, to go into chambers physically if you could attend all hearings remotely. So whilst there are undoubtedly advantages to having virtual hearings, I think we have to be conscious of the potential risks and pitfalls as well. Because in the drive for convenience and expediency, I think we can perhaps lose sight of what's good about what we do, the ability to connect with people on a human level, to speak up for them in a way that's impactful and powerful, and also forging those relationships and personal connections with local solicitors, with colleagues and barristers in chambers. All of that could be undermined if we push virtual hearings too far. So those are a few reflections from me. I hope you found it useful to look at some of the do's and don'ts in terms of virtual hearings, and to look at the future and what that might have in store for us. Thank you. I hope you found this evening's talks to be useful. I'll just say a few words in closing. I can echo what Chris has said. I would encourage you to buy the book if you'd like to read it. We're very pleased with what we've put together, and I hope you will find it useful if you want to buy it. Thank you very much for attending this evening. As I say, I hope you found the topics useful and that they provide some food for thought, but also some quite practical advice and guidance as well. Thank you very much for joining us this evening, and we certainly hope to see you on the 10th of December for the sequel to this webinar. Thank you very much.